Adnan Syed is back with his family this morning after a Baltimore judge overturned his conviction in the 1999 murder of his girlfriend, Heyman Lee, and ordered his release from prison.
Yeah, there are questions right now, Joe, regarding whether Syed received a fair trial, which started to arise after the case was featured on the popular Serial podcast back in 2014. And the judge said that prosecutors did make a compelling argument that Syed's conviction was flawed.
Becky Feldman subsequently led nearly a year-long exhaustive investigation reviewing the substantive facts of this case, where several problematic issues were presented, and thereafter leading my office to file a motion to vacate the conviction of Adnan Syed.
NBC legal analyst Danny Cevallos joins us right now. Danny, good morning.
Good morning.
Break this down for us as we find out that prosecutors now have identified two alternative suspects, potentially exculpatory information. How does that not get out beforehand? And what are they arguing here?
They've identified two alternate suspects, but they haven't identified them. In other words, they are just referring to them as one of the suspects. And in a short summary, they've alleged essentially that one of the suspects threatened the victim. One of the suspects had a history of assaulting, including sexual assault. So these are all things that should have been disclosed to the defendant under the Brady rule, which means that if the prosecution or the state has evidence that's exculpatory, it's material to guilt or innocence, they have to turn it over to the defense. Now, your second question is my question. With all the attention on this case, is there any other case that has gotten more attention than the Adnan Syed case? Why was it not disclosed if it was known to the prosecution at the time? And the answer is, as a criminal defense attorney, a jaded criminal defense attorney, is that, well, this happens all the time. And the reality is, especially in state courts, these cases are mass processed. There's a lot of sloppiness, both on defense and the prosecution side. And this is something that was somehow missed, even during the appeals and post-conviction attacks. And somehow only now, in 2022, does the state finally say, 20 plus years later, there might have been some evidence that we should have disclosed to this defendant.
We don't think you're jaded. We just think you ask good questions. So, and on top of all that, you've got in 2016, there was a Maryland judge cited doubts over the cell phone evidence, which was a big part of the podcast, over why there should even maybe be a new trial in this case. So why has it even taken long since that to get to this point?
Because the mere fact that there may be newly discovered evidence, and you see this in the procedural appeals process for Syed's case, it's not enough that there may have been evidence that the defense should have known about. Another key problem for the incarcerated challenging their convictions is whether or not their attorney raised it. Because there's this rule, a use it or lose it rule. In criminal cases, if your attorney doesn't object or raise the issue at the trial court level, often it is lost forever. A decision made by your attorney, not by the actual defendant, that may have effects for the rest of the case. So if the attorney doesn't raise the objection, it might be waived. And you see that throughout the appeals process. Courts at each level of the appeal saying, this might have been an issue, but did the defense attorney properly raise it? And does she have an excuse for never raising it? Again, the defendant ends up being held accountable for the attorney's mistakes.
So the ball was dropped legally from multiple vantage points here.
Yes.
But I guess the question now is, we've talked about all of these complications. Syed's name isn't cleared yet. What happens next?
Okay, now this is an exclusive you're getting just from me. You probably won't get it anywhere else. This is my theory. The prosecution now has 30 days in which to retry the case. They will quietly ride off into the night. That's my theory. They will not retry Syed. The reason is this. Maryland recently enacted a wrongful conviction statute. Notice in the motion, the state said, well, we think there were irregularities, but we're not saying he's innocent. Now, why go to all that fanfare to say, we don't necessarily think he's innocent? Well, again, this may be jaded defense attorney talk, but when you look at the wrongful conviction statute in Maryland, it requires essentially an actual innocence standard. In other words, for Syed to get paid, to submit an invoice to the state of Maryland for wrongfully convicting and incarcerating him, he has to be actually innocent. The statute uses a slightly different term, but if the state in its motion said, well, now we think he's innocent, they've essentially put the state of Maryland on the hook for compensating Syed. And they're not ready to do that yet. They'd rather make Syed work for it, and work for it, I guarantee he will. The next step is likely, if they choose not to retry him, a civil filing or whatever the procedural equivalent is in Maryland.
All right.
You'd have to think he's taking legal action.
Yeah.
Danny, thank you so much.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.